Objectives. Hello students, welcome to the lecture on Information Technology Act 2000. After this lecture, you will be able to learn the following objectives. Explain the digital signature, discuss the electronic governance, define attribution, acknowledgement and dispatch of electronic records, discuss the secure electronic records and secure digital signatures, understand the regulations of certifying authorities, explain the digital signature certificates, describe the duties of subscribers. Now let us know more about information technology. The term information technology, IT, is not having a precise meaning. It is generally applied to broad area of activities and technologies associated with the use of computers and communication. We can explain IT as an application of computers to create, store, process and use of information, particularly in the field of commerce. Basically, IT enables the corporate management to have access to timely, accurate and relevant data with the use of computers, communication, telephone, internet. The Information Technology IT Act 2000 has been designed to give boost to electronic commerce, e-commerce, e-transactions and similar activities associated with commerce and trade, and also to facilitate electronic governance, e-governance, by means of reliable electronic records. The term electronic commerce, e-commerce, refers to the business transacted electronically. In common usage, the term refers to trading of goods over the internet. It is online sale and purchase of goods and services for value by using internet technologies such as internet processing, email and World Wide Web www or just web browsing. The term electronic governance refers to the application of information technology to the process of government functioning in order to bring about simple, moral, accountable, responsive and transparent smart governance. Digital signature. Now let us view this video for a brief understanding of the topic digital signatures. Authentication of the record has to be achieved by some electronic or digital method. Affixing digital signature has been defined of the Act to mean adoption of any methodology or procedure by a person for the purpose of authenticating an electronic record by means of digital signature. Authentication of electronic records, Section 3. Any subscriber may authenticate an electronic record by affixing his digital signature. The authentication of the electronic record shall be effected by the use of asymmetric crypto system and has hash function which envelop and transform the initial electronic record into another electronic record. For the purposes of this subsection, hash function means an algorithm mapping or translation of one sequence of bits into another, generally smaller set known as hash result, such that an electronic record yields the same hash result every time the algorithm is executed, with the same electronic record as its input making is computationally infeasible. To derive or reconstruct the original electronic record from the hash result produced by the algorithm. That two electronic records can produce the same hash result using the algorithm. Verification. Any person, by the use of a public key of the subscriber, can verify the electronic record. The private key and the public key unique to the subscriber and constitute a functioning key pair. Electronic governance. With a view to facilitating electronic governance, IT Act 2000 accords legal recognition to electronic records, digital signatures, and electronic form of dealing with government offices and its agencies. The retention of information in electronic format has also been accorded legal recognition, provided the information remains accessible and usable in future. The Act contains the following provisions to facilitate e-governances. Legal recognition of electronic records, Section 4. Where any law provides that information or any other matter shall be in writing or in the typewritten or printed form, then, notwithstanding anything contained is such law, such requirements shall be deemed to have been satisfied if such information or matter is rendered or made available in an electronic form, accessible so as to be usable for a subsequent reference. Legal recognition of digital signatures, Section 5. Where any law provides that information or any other matter shall be authenticated by affixing the signature, or any document shall be signed or bear the signature of any person, then, notwithstanding anything contained in such law, requirement shall be deemed to have been satisfied if such information or matter is authenticated by means of digital signature affixed in such manner as may be prescribed by the central government. Use of electronic records and digital signatures in government and its agencies, Section 6. Where any law provides for the filing of any form, application, or any other document with any office, authority, body, or agency owned or controlled by the appropriate government in a particular manner. The issue or grant of any license, permit, sanction, or approval by whatever name called in a particular manner. The receipt or payment of money in a particular manner, notwithstanding anything contained in any other law for the time being in force, such requirement shall be deemed to have been satisfied in such filing, issue of grant, receipt, or payment, as the case may be, is effected by means of such electronic form as may be prescribed by the appropriate government. The appropriate government may, by rules, prescribe the manner and format in which such electronic records shall be filed, created, or issued, the manner or method of payment of any fee or charges for tilling, creation, or issue of any electronic record under Clause A stated above. Retention of electronic records, Section 7. Where any law provides that documents, records, or information shall be retained for any specific period, then that requirement shall be deemed to have been satisfied if such documents, records, or information are retained in the electronic form, if the information contained therein remains accessible so as to be usable for a subsequent reference. The electronic record is retained in the format in which it was originally generated, sent or received, or in a format which can be demonstrated to represent accurately the information originally generated, sent or received. The details which will facilitate the identification of the origin, destination, date and time of dispatch or receipt of such electronic record are available in the electronic record. Publication of rules, regulations, etc. in Electronic Gazette, Section 8. Where any law provides that any rule, regulation, order, bylaw, notification or any other matter shall be published in the official gazette, then such requirement shall be deemed to have been satisfied if such rule, regulation, order, bylaw, notification or any other matter is published in the official gazette or electronic gazette. No right to insist that the document should be accepted in electronic form, Section 9. Sections 6, 7 and 8 shall not confer a right upon any person to insist that any ministry or department of the central government or the state government or any authority or body established by or under any law or controlled or funded by the central or state government should accept, issue, create, retain and preserve any document in the form of electronic records or effect any monetary transaction in the electronic form. Central government empowered to make rules in respect of digital signature, Section 10. The central government is empowered to make rules in respect of digital signature prescribing the type of digital signature, the manner and format in which the digital signature shall be affixed, the manner or procedure which facilitates identification of the person affixing the digital signature, control processes and procedures to ensure adequate integrity, security and confidentiality of electronic records or payments. Any other matter which is necessary to give legal effect to digital signatures, attribution, acknowledgement and dispatch of electronic records. Under this heading, the IT Act 2000 contains provisions regarding A. When the transmission of an electronic record shall be attributed to the originator. B. Would the addressee or receiver be bound to acknowledge the receipt of that electronic record? C. How to determine the time and place of dispatch and receipt of electronic record. Attribution of electronic records, Section 2. An electronic record shall be attributed to the originator if it was sent by the originator himself, by a person who had the authority to act on behalf of the originator in respect of that electronic record, by an information system programmed by or on behalf of the originator to operate automatically. Originator. It means a person who sends, generates, stores or transmits any electronic message or causes any electronic message to be sent, generated, stored or transmitted to any other person but does not include an intermediary. Intermediary. Intermediary with respect to any particular electronic message means any person who on behalf of another person receives, stores or transmits the message or provides any service with respect to that message. Addressee. It means a person who is intended by the originator to receive the electronic record but does not include any intermediary. Acknowledgement of receipt, Section 12. No agreement. Where the originator has not agreed with the addressee that the acknowledgement of receipt of electronic record be given in a particular form or by a particular method. An acknowledgement may be given by any communication by the addressee, automated or otherwise, any conduct of the addressee sufficient to indicate to the originator that the electronic record has been received. Stipulation by the originator. Where the originator has stipulated that the electronic record shall be binding only on receipt of an acknowledgement of such electronic record by him, then unless acknowledgement has been so received, the electronic record shall be deemed to have been never sent by the originator. No stipulation by the originator. Where the originator has not stipulated that the electronic record shall be binding only on receipt of such acknowledgement, and the acknowledgement has not been received by the originator within the time specified or agreed, or if no time has been specified or agreed to within a reasonable time, then the originator may give notice to the addressee stating that no acknowledgement has been received by him and specifying a reasonable time by which the acknowledgement must be received. Time and place of dispatch and receipt of electronic record, section 13. Save as otherwise agreed to between the originator and the addressee, the dispatch of an electronic record occurs when it enters a computer resource outside the control of the originator. Save as otherwise agreed between the originator and the addressee, the time of receipt of an electronic record shall be determined as follows, namely, if the addressee has designated a computer resource for the purpose of receiving electronic records, A. Receipt occurs at the time when the electronic record enters the designated computer resource. B. If the electronic record is sent to a computer resource of the addressee that is not the designated computer resource, receipt occurs at the time when the electronic record is retrieved by the addressee. If the addressee has not designated a computer resource along with specified timings, if any, receipt occurs when the electronic record enters the computer resource of the addressee. Save as otherwise agreed to between the originator and the addressee, an electronic record is deemed to be dispatched at the place where the originator has his place of business and is deemed to be received at the place where the addressee has his place of business. For the purpose of this section, if the originator or the addressee has more than one place of business, the principal place of business shall be the place of business. If the originator or the addressee does not have a place of business, his usual place of residence shall be deemed to be the place of business. Usual place of residence in relation to a body corporate means the place where it is registered. Secure electronic records and secure digital signatures. Secure electronic record, section 14. Where any security procedure has been applied to an electronic record at a specific point of time, then such record shall be deemed to be a secure electronic record from such point of time to the time of verification. Secure digital signature, section 15. If by application of a security procedure agreed to by the parties concerned, it can be verified that a digital signature at the time it was affixed was unique to the subscriber affixing it, capable of identifying such subscriber, created in a manner or using a means under the exclusive control of the subscriber, and is linked to the electronic record to which it relates in such a manner that if the electronic record was altered, the digital signature would be invalidated, then such digital signature shall be deemed to be a secure digital signature. Security procedure, section 16. The central government shall, for the purposes of this act, prescribe the security procedure having regard to commercial circumstances prevailing at the time when the procedure was used, including the nature of the transaction, the level of sophistication of the parties with reference to their technological capacity, the volume of similar transactions engaged in by other parties, the availability of alternatives offered to but rejected by any party, the cost of alternative procedures, The procedures in general used for similar types of transactions or communications. Regulation of certifying authorities. With a view to creating regulation for certification, the IT Act 2000 provides for the appointment, functions, powers and duties of controller of certifying authorities and other officers. The Act also provides for the functions and duties of certifying authorities. Appointment of controller and other officers, Section 16. The central government may, by notification in the official gazette, appoint a controller of certifying authorities for the purpose of this Act and may also, by the same or subsequent notification, appoint such number of deputy controllers and assistant controllers as it deems fit. The controller shall discharge his functions under this Act subject to the general control and directions of the central government. The deputy controllers and assistant controllers shall perform the functions assigned to them by the controller under the general superintendence and control of the controller. The qualifications, experience and terms and conditions of service of controller, deputy controllers and assistant controllers shall be such as may be prescribed by the central government. The head office and branch office of the office of the controller shall be at such places as the central government may specify, and there shall be a seal of the office of the controller. Functions of controller, Section 18. The controller may perform all or any of the following functions, namely, exercising supervision over the activities of the certifying authorities, certifying public keys of the certifying authorities, laying down the standards to be maintained by the certifying authorities, specifying the qualifications and experience which employees of the certifying authorities should possess, specifying the conditions subject to which the certifying authorities shall conduct their business, specifying the contents of written, printed or visual materials and advertisements that may be distributed or used in respect of a digital signature certificate and the public key, specifying the form and content of a digital signature certificate and the key, specifying the form and manner in which accounts shall be maintained by the certifying authorities, specifying the terms and conditions subject to which auditors may be appointed and the remuneration to be paid to them, facilitating the establishment of any electronic system by a certifying authority either solely or jointly with other certifying authorities and regulation of such systems, specifying the manner in which the certifying authorities shall conduct their dealings with the subscribers, resolving any conflict of interest between the certifying authorities and the subscribers, laying down the duties of the certifying authorities, maintaining a database containing the disclosure record of every certifying authority containing such particulars as may be specified by regulations which shall be accessible to public. Recognition of foreign certifying authorities, Section 19. Subject to such conditions and restrictions as may be specified by regulations, the controller may, with the previous approval of the central government and by notification in the official gazette, recognize any foreign certifying authority as a certifying authority for the purpose of this Act. Revocation of recognition. The controller may, if he is satisfied that any certifying authority has contravened any of the conditions and restrictions subject to which it was granted recognition under subsection, he may, for reasons to be recorded in writing by notification in the official gazette, revoke such recognition. Controller to act as repository, Section 20. A repository is an online database of digital signature certificates and other related information useful for those who conduct their business operations through the medium of computer internet or e-commerce. The controller shall be the repository of all digital signature certificates issued under this Act. To ensure that the secrecy and security of the digital signatures are assured, the controller shall make use of hardware, software, and procedures that are secure from intrusion and misuse, observe such other standards as may be prescribed by the central government. Grant of license to certifying authorities to issue digital signature certificates, Section 21. Any person may make an application to the controller for a license to issue digital signature certificate, provided he fulfills such requirement with respect to qualification, expertise, manpower, financial resources, and other infrastructure facilities which are necessary to issue digital signature. A license granted under this section shall be valid for such period as may be prescribed by the central government, not be transferable or heritable, be subject to such terms and conditions as may be specified by the regulations. Application for license. Every application for issue of a license shall be in such form as may be prescribed by the central government. The application for issue of a license shall be accompanied by a certificate practice statement, a statement including the procedures with respect to identification of the applicant. Payment of such fees not exceeding 25,000 rupees may be prescribed by the central government. Such other documents as may be prescribed by the central government. Certification practice statement. It means a statement issued by a certifying authority to specify the practices that it employs in issuing digital signature certificates. This statement specifies a set of rules and requirements which are to be followed by a certifying authority CA in its operation and issuing certificates. Procedure for grant or rejection of license. The controller may, on receipt of an application for a license to issue digital signature certificate, after considering the documents accompanying the application, such other factors as he deems fit, grant the license or reject the application. Renewal of license. An application for renewal of a license shall be A. in such form, B. accompanied by such fees not exceeding 5,000 rupees as may be prescribed by the central government, and shall be made in less than 45 days before the date of expiry of the period of validity of the license. Suspension of license. The controller may, if he is satisfied after making an inquiry, revoke the license where a certifying authority has made a statement in or in relation to the application for the issue or renewal of the license which is incorrect or false in material particulars, failed to comply with the terms and conditions subject to which the license was granted, failed to maintain the standards specified by the central government, contravened any provisions of this act, rule, regulation or order made thereunder. However, no license shall be revoked unless the certifying authority has been given a reasonable opportunity of showing cause against the proposed revocation. Notice of suspension or revocation of license. Where the license of the certifying authority is suspended or revoked, the controller shall publish notice of such suspension or revocation as the case may be. Any other fact that materially and adversely affects either the reliability of a digital signature certificate which that authority has issued or the authority's ability to perform its services, to make reasonable efforts to notify any person who is likely to be affected by the occurrence of any event which in the opinion of the certifying authority may materially and adversely affect the integrity of its computer system or the conditions subject to which a digital signature certificate was granted. Digital signature certificates. The purpose of a digital signature certificate is to authenticate the identity of an individual. It ensures that the purported sender is in fact the person who sent the message. It is signed digitally by the certifying authority. Certifying authority to issue digital signature certificate, Section 35. Application. Any person may make an application to the certifying authority for the issue of a digital signature certificate in such form as may be prescribed by the central government. The application shall be accompanied by such fee not exceeding 25,000 rupees as may be prescribed by the central government. However, different fee may be prescribed for different classes of applicants. By a certification practice statement, or where there is no such statement, a statement containing such particulars as may be specified by regulations. Grant of certificate. On receipt of an application for the issue of digital signature certificate, the certifying authority may, after consideration of the certification practice statement or the other statement referred above, and after making such inquiries as it may deem fit, grant the digital signature certificate, or for reasons to be recorded in writing, reject the application. However, no digital signature certificate shall be granted unless the certifying authority is satisfied that the applicant holds the private key corresponding to the public key to be listed in the digital signature certificate. The applicant holds a private key which is capable of creating a digital signature. The public key to be listed in the certificate can be used to verify a digital signature affixed by the private key held by the applicant. Representation upon issuance of digital signature certificate, Section 36. While issuing a digital signature certificate, the certifying authority certifies that the information contained in it is accurate and that it is complied with the provisions of this Act and the rules and regulations made thereunder. It has published the digital signature certificate or otherwise made it available to such person relying on it, and the subscriber has accepted it. The subscriber holds the private key corresponding to the public key listed in the digital signature certificate. The subscriber's public key and private key constitute a functioning key pair. It has no knowledge of any material fact which, if it had been included in the digital signature certificate, would adversely affect the reliability of the representations made in clauses A to D. Suspension of digital signature certificate, Section 37. The certifying authority which has issued a digital signature certificate may suspend such digital signature certificate at receipt of a request to that effect from A. the subscriber listed in the digital signature certificate, B. any person duly authorized to act on behalf of that subscriber. If it is of opinion that the digital signature certificate should be suspended in public interest, a digital signature certificate shall not be suspended for a period exceeding 15 days unless that subscriber has been given an opportunity of being heard in the matter. Revocation of digital signature certificate, Section 38. A certifying authority may revoke a digital signature certificate issued by it where the subscriber or any other person authorized by him makes a request to that effect or in the database maintained by him. Where one or more repositories are specified, the controller shall publish notices of such suspension or revocation as the case may be in all such repositories. Power of controller. The controller of certifying authorities has the following powers. Power to authorize in writing the deputy or the assistant controller or any officer to exercise any office powers. Power to take up for investigation any contravention of the Act or rules or regulations made thereunder. He may authorize any officer also in his behalf. Power to exercise himself or through an authorized officer, like powers which are conferred on income tax authorities under Chapter 13 of the Income Tax Act 1961. A few such powers are briefly stated below. Powers as are vested in the court when trying a suit in respect of matters relating to inspection, enforcing attendance of any person, and examining him on oath compelling the production of books of account, etc. Power to enter and search any building, place, etc., where books of accounts, documents, or valuables are believed to be kept, and seize them. Power to requisition books of account or assets from any officer possessing them. Power to call for information. Power to make inquiries. Power to direct by order a certifying authority or any employee of such authority to take such measures or cease carrying on such activities as specified in the order if those are necessary to ensure compliance with the provisions of the Act, rules, or any regulations made thereunder. Power to direct, by order, any agency of the government to intercept any information transmitted through any computer resource if it is necessary expedient in the interest of the sovereignty or integrity of India, the security of the state, friendly relations with foreign states, or public order, or for preventing incitement to the commission of any cognizable offence. Access to computers and data, Section 39. If the controller has reasonable cause to suspect that any contrition of this provisions of this Act, rules or regulations made thereunder been committed, the controller or any other person authorized by shall have access to any computer system, any apparatus, data, or other material connected with such system for the purpose of search or causing a search to be made for obtaining any information or data contained in or available to such computer system. Duties of subscribers. Generating key pair, Section 40. Where any digital signature certificate, the public key of which corresponds to the private key of that subscriber, which is to be listed in the digital signature certificate, has been accepted by a subscriber, then the subscriber shall generate the key pair by applying the security procedure. Acceptance of digital signature certificate, Section 41. A subscriber shall be deemed to have accepted a digital signature certificate if he publishes or authorizes its publication to one or more persons in a repository, or if he otherwise demonstrates his approval in any manner. Subscriber representation. By accepting a digital signature certificate, the subscriber certifies to all who reasonably rely on the information contained therein that A. He holds the private key corresponding to the public key listed in the digital signature certificate and is entitled to hold the same. B. All his representations to the certifying authority and all material relevant information contained in the certificate are true. C. All information in the certificate that is within his knowledge is true. Control of private key, Section 42. Every subscriber shall exercise reasonable care to retain control of the private key corresponding to the public key listed in his digital signature certificate. Penalties and adjudication. In spite of security measures adopted by an owner of the computer system and computer network, there are theft and intrusion. Legal protection has therefore been provided against the wrongdoers. Under the Act, penalty is imposed by way of damages to be paid as compensation to the affected party for damage caused to any computer, computer network, etc. by introduction of computer virus, unauthorized access, and other types of mischief. Penalty for damage to computer system, etc. Section 43. If any person indulges in any of the following acts, he shall be liable to pay damages by way of compensation not exceeding 1 crore rupees to the person so affected. Accesses or secures access to such computer system, or computer network. Downloads, copies, or extracts any data, computer database, or information from such computer system, or computer network, including information or data held or stored in any removable storage medium, shall be deemed to be civil court for the purposes of Section 345 and 346 of the Code of Criminal Procedure 1973. Factors to be taken into account by the adjudicating officer, Section 47. While adjudging the quantum of compensation, the adjudicating officer shall have due regard to the following factors, namely, the amount of gain of unfair advantage, wherever quantifiable, made as a result of the default, the amount of loss caused to any person as a result of the default, the repetitive nature of the default. Now, in the end, let us summarize what we have learnt in this lecture. The term information technology, IT, is not having a precise meaning. It is generally applied to broad area of activities and technologies associated with the use of computers and communication. The term electronic commerce, e-commerce, refers to the business transacted electronically. In common usage, the term refers to trading of goods over the internet. It is online sale and purchase of goods and services for value by using internet technologies such as internet processing, email and World Wide Web, www, or just web browsing. The authentication of the electronic record shall be affected by the use of asymmetric crypto system and hash function which envelop and transform the initial electronic record into another electronic record.